So, as Professor Deák mentioned, I'm writing my PhD on this topic, but I know that there are some outsiders here. So maybe I would like to start my presentation with a brief introductory to this topic with the basic terms of the field, and then I would like to turn to the Hungarian legislation. So, first, a clarification of the substantial terms. We can distinguish between active and passive forms of euthanasia. In the case of active euthanasia, the doctor is the person who administers the dose to the person who wishes to receive it, as Professor mentioned, to killing the patient. But if the doctor only provides the little dose, then and the patient is the one who is taking it, then it is only assisted suicide. And of course, we can distinguish between passive and active forms of euthanasia. Passive is the right to refuse life-saving or life-sustaining treatment. And now I would like to turn to a brief introductory about the legal situation in Europe. A survey covering 42 Council of Europe member states was recently carried out in the recent years, I think in 2022. The refuse of therapeutic treatment, so passive euthanasia, is permitted in 27 member states, subject to the certain conditions, of course. Active euthanasia, when the doctor himself administers the dose, is legal in 5 other countries. As the slide shows, these are the Benelux countries, Spain and Portugal. And assisted suicide, when the patient takes the pills himself or herself, prescribed by the doctor, is legal in 7 other countries, namely Austria, Finland, Germany, Italy, Liechtenstein, Sweden and Switzerland. And of course, in Italy and Germany have only decriminalized assisted suicide, so no specific procedure has been adopted for how a doctor can assist in this procedure. And in addition, it is important to note that several countries are in the process of consulting on the legislation of assisted suicide, like, for example, Wales, England, and France. Although Hungary was not included in this study, we are one of the countries where passive euthanasia is allowed under certain strict conditions. In the following, I would like to present the Hungarian legal framework. And I would like to start my presentation about Hungary with the personal coverage of the penal code. The criminal code provides for the punishment of offenses committed by a Hungarian citizen abroad, which constitute a criminal punishment of offenses under national law. But foreigners who commit the offense abroad and there is a situation of double incrimination, both countries criminalize the offense are punishable as well. In this case, therefore, if a foreign doctor were to perform euthanasia on a patient, he would be punishable if he is punishable under the law of that country. This is obviously unlikely to happen since the patient wouldn't go to such a country where the euthanasia is illegal. So the main problem is the passive person principle here in Hungary, and this was disputed in a recent case in front of the European Court of Human Rights. So without any double incrimination, is the foreign doctor punishable if the patient is Hungarian? Of course, in this case, the prosecutor general has the right to decide whether or not to prosecute, but the patient will not know the outcome of this decision, so he cannot make this decision with this knowledge. According to the penal code, active euthanasia would constitute homicide, while assisted suicide is a separate offense in our criminal code. If the doctor simply prescribed the pills, he will be prosecuted for assisted suicide as he had provided help for the patient. Assisting suicide includes not only providing aid, but also persuading, but this would only be the case if the doctor wouldn't properly inform the patient and would induce him to commit suicide. This is, of course, unlikely to happen in the reality. But then I would like to turn off the legal field in the era of end-of-life decisions. So as I mentioned, the passive euthanasia is legal, but under certain conditions. We have our Healthcare Act, and the patient may refuse life-saving or supporting treatment according to it if he or she suffers in a serious illness which, according to the current state of medical knowledge, will lead to a death within a short time, even with appropriate treatment. The refusal is valid if a 3-member medical committee declares in writing that the patient has made the decision in full knowledge of the consequences and the patient restates its intention on the 3rd day after the examination. Now I would like to turn to the recent case of Deák. This is a quite famous Hungarian case, and this was the latest case in this field in front of the European Court of Human Rights. So Daniel Kőszeg was a 47-year-old Hungarian famous human rights lawyer, and he was dealing with this topic for years. He was diagnosed with ALS in 2022. This disease is fatal in all cases with a gradual loss of voluntary muscle movement, while the patient retains mental capacity for the rest of his life. The patient needs daily assistance, soon becomes completely paralyzed and, so to say, prisoner in his own body with full mental abilities. He would have committed suicide alone only in the early stage of his disease, but of course he didn't want to do so. And in the future, when he wanted to die, he would definitely need some help from someone, from a relative or from a doctor. In the current Hungarian situation, this could be achieved by a relative taking him to a country where euthanasia is legal, in which case the relative or even the foreign doctor could be held liable for assisting in his suicide. Of course, you don't want to put anyone through this whole procedure, and that's why he didn't decide to do so. And the option of passive euthanasia is unlikely to be the one that he would be able to live with because he didn't need life-sustaining treatments. Daniel Kőszeg has turned to the European Court of Human Rights because he claims that Hungarian legislation violated his rights to private life, which he believes should include in the end-of-life decisions based on self-determination. In particular, he wanted Hungary to legalize certain types of assisted suicide under strict conditions, of course. If this is not possible, then he wanted to ensure that the criminal code wouldn't hold liable any of his relatives or the foreign doctor. He argued that the state should provide an alternative for patients who do not yet need life-sustaining treatment, but who are no longer able to receive adequate help from palliative care. He also pointed out that euthanasia is increasingly accepted by the public, and the Hungarian legislation has not been reviewed since 1878. So according to the Hungarian government, countries should not be under a positive obligation to ensure some form of assisted suicide, which is of course true, as intentional deprivation of life is prohibited by the convention. They also highlighted the problem of irreversibility of the decision and the risk of misuses. The government considers deep sedation as a dignified end to a life. As they do not want to encourage patients to travel abroad to receive euthanasia, since this would lead to discrimination. And the abolition of the passive personal principle, according to the Hungarian government, would mean that the Hungarian citizens wouldn't enjoy adequate legal protection abroad. So the court ruled that the issue of assisted suicide should indeed be dealt with with a member state level, as they are in a position to judge the public opinion, the resources, and the social situation in that specific country. According to the court, there is no common European position yet, and the issue raises very deep moral and ethical questions. The judgment states that the state is not obliged to provide an alternative to passive euthanasia for patients who cannot or want not to have it. Palliative care should be sufficient to ensure a dignified life for patients. In addition, the court also did not consider it disproportionate that Hungary also punishes assisted suicide committed abroad, and this was a new element in this judgment, since I would consider it disproportionate compared to the punishments. Daniel Kőszeg also argued that Hungary had breached the requirement of equal treatment by failing to provide him, who also suffers from a terminal illness, the opportunity to shorten his life, while those persons who need this life-sustaining treatment can request it in the form of a refusal treatment. According to the government, Daniel Kőszeg is not in the same situation as the patients who need life-sustaining treatment. Moreover, refusing treatment is not the same as helping someone to die, but simply allowing the disease to lead to the normal weight on the death. After the judgment, Daniel Kőszeg tried to bring the case before the Grand Council, but it was unsuccessful, unfortunately. And of course, there are many other references in the judgment which may be relevant to be involved in the euthanasia debate, but this short presentation will only cover these main arguments. At the end of my presentation, I would like to introduce some other arguments, but maybe because of the time, I won't have the capacity to talk about all of this, but I think this is a good start to have a conversation about it. So you can see it on the slide. And finally, I would like to turn to my conclusions, which I hope will serve a little thought starter in the field. In the court's view, a member state cannot be obliged to legalize euthanasia because it would put the right to life on an equal level with the right to death. On the contrary, some argue that it is not the right to life that is opposed to the right to death, but the state's duty to protect life versus the right to self-determination. As long as suicide is based on free will, the state should respect it. However, when in doubt, the state's duty to protect lives comes to the fore, as it appears in the German Constitutional Court regulation. However, it is not a legal question, in my opinion, to determine when this is based on free will or when this is not the case. That's why I believe that other sciences should be also included in this debate. Thank you very much for your attention.